Stay away from me. Perfect. Yeah. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division, are near, give me attendance, and shall be heard. Please be seated. Good afternoon and welcome to the Appellate Division, First Department. Although you see only 4 of us on the bench, Justice Gonzalez is part of the panel, and as you can see on the screen, she is participating in the oral argument and is as a member of this panel. There are almost 3 hours of requested argument time for today, and I therefore ask you to reduce your requests to what you reasonably must have. People versus Jenkins. 5 and 2 and 5. Pacheco versus Santos. Do you want to submit? No, thank you very much. I'll mark it as submission. Matter of Madeline M., submitted. Pope Contracting versus NYCHA. No appellant? Do you want to submit? I'll mark it as submission. Clendenin versus VOA of America. Excuse me? My opposition is not here, so appellant, I have a 5, but I'll submit. I'll mark it as submission. Thank you. People versus Hanford. Submitted. Fundos versus Scarola. Matter of Unique T. Submitted. Landmark Group versus New York City Schools Construction. Bota versus Elite Limousine, submitted. Verdugo versus Smiley. Are we arguing both cases together, or are you going to do it separately?
Separately, Your Honor.
2 and 1 and 2. And Verdugo versus Smiley. Thank you. People versus Jenkins.
Good afternoon, Your Honors. Richard Hirschfeld for Appellant. The first issue I'd like to address is jurisdiction, which really boils down to, did the prosecution prove that appellant knew the crimes, the guns, would ultimately be sold in New York? And as indicated in the brief, there was no proof of that, and whatever proof there was circumstantial and certainly wasn't the only, a knowledge in New York was certainly not the only conclusion that could be drawn from that circumstantial evidence. In essence, you had 3 recorded conversations, one in which...
you also have, isn't there an indication that the defendant's vehicle is parked near Davis's residence?
I believe there was testimony at one point that his vehicle was near Davis's residence, but that wasn't in New York, so I'm not sure how you draw from that.
But there are these intercepted conversations in which there are matters discussed which are susceptible to being understood as indicating that there's going to be a transaction taking place in New York, and the defendant is assisting in that. And a lot went on in New York. I mean, what is it, 80, were there 80 transactions in New York between Davis and the undercover?
Between Davis and, but not involving appellant. Appellants was
Right,
extremely
right,
limited.
but the appellant is in conversation. I mean, the idea that the appellant has something to do with Davis is not like a made-up story. I mean, you've got intercepted conversations.
No one's suggesting that there wasn't a relationship between appellant and Davis. The problem is that there was nothing to bring New York into the picture.
Well, wasn't there some sort of information on one of those recordings that defendant mentioned that he was going to go to New York, and Davis responded that if things worked out, he would definitely go to New York on Saturday, and another indication of going up top, and the detective testified that up top referred to New York. Why couldn't the jury infer, based upon those calls, the knowledge?
Well, first of all, the conversation that appellant was going to New York and Davis might go to New York, that actually, I think, cuts the other way, because what Davis said was that after he gets done with something else, he might go over to New York. So that suggests that the sales are actually taking someplace other than in New York. The up top comment, again, that's just one more indicia of ineffective assistance. That should never have been asked of the officer by defense counsel, but even still, that's simply a conclusory statement. That's not something, there was nothing that the officer said that this was code language. Up top could be anything. He lives in New Jersey. Why couldn't up top be New Jersey? There are any number of states involved in this: Virginia, North Carolina, South Carolina. Why couldn't up top just be someplace?
Because didn't the detective explain that up top meant New York, and then that becomes a credibility issue, right? The jury is either free to believe him or not, and in this instance, maybe they credited that testimony.
Well, except for the fact that this would be circumstantial evidence, and with circumstantial evidence, the conclusion or the inference has to be the only one that can be fairly drawn from the evidence.
Well, what about the Lawson pistol, which there's a discussion between Davis and the defendant, with Davis asking the defendant what it looked like, and defendant responding that it looked brand new but was scratched up, obviously meaning that the serial number has been scratched off. He says, in fact, it scratched the serial numbers off. And then the next day, Davis apparently sells that gun to the undercover. That doesn't create a clear inference of defendant being involved in this transaction, which takes place in New York?
Well, again, it would be very hard to argue that defendant wasn't involved in these transactions. But the question is whether he knew that these transactions were to take place in New York for New York to exercise jurisdiction. And with that particular pistol, there was nothing to suggest that it was going to be sold in New York. It was just
It just ends up getting sold in New York.
Exactly. But the result doesn't prove the element that the prosecution is required to prove beyond a reasonable doubt. That appellate had knowledge that it was in New York. The court charged that the jury had to find that. The law is that appellant had to know that. And I think this court, even if the court concludes that there's some vestige of proof of jurisdiction, the court can still conclude that any conclusion that appellant knew is against the weight of the evidence. So if there are no other questions, I see the light is on, so thank you.
Thank you, Mr. Hertzfeld.
Good afternoon, Your Honors. Sylvia Wertheimer for the people. The evidence showed the defendant was an active member of this gun trafficking operation in which Abdul Davis.
So what's your response to the argument that, sure, there's an indication, let's say, as to the Lawson pistol that there's conversation between defendant and Davis, but what about that shows, what evidence is there which shows that the defendant knew that this was going to take place in New York?
Well, okay, he doesn't have to know that every, with respect to the accomplice liability for the sales, the basis for jurisdiction would be 20.21A, which just required, didn't require that he necessarily knew that there was this particular one. Okay, let me answer, I'm sorry, go back. The evidence, you look at this is an ongoing relationship. There's a close
Because I
relationship.
remember you were starting to say that there is no specific evidence which ties that to defendant knowing. But so in general, what's the evidence? Do you agree that the people had to show that the defendant knew it was going to take place in New York? And if you do agree with that, what evidence do you point to as showing the defendant knowing this?
Okay. Yes, we do agree that the evidence had to show that he knew the sales were going to take place in New York. They're the intercepted communications. The intercepted communications indicate that there's a very close personal relationship between the defendant and Davis, and also that Davis knows these other suppliers. So the notion that this is just some arm's-length transaction that's going on is totally belied by the totality of the...
Well, counsel, in some of these instances, there was weeks delay in between the phone calls and then when the guns were then subsequently sold in New York. Does that delay somehow hurt or maybe support the defendant's position that he wouldn't have known?
No, I don't believe so. I think that would just go to the proof of that the defendant had supplied the relative guns, but not the jurisdiction. The jurisdiction is, this operation was specifically set up to only prosecute people who mentioned New York in the communications, and there were 3 intercepted communications between defendant and Davis that referred to New York in the context that allowed the jury to infer, that really compelled the inference that he knew that these guns that were being supplied to Davis from Southern suppliers, him and other Southern suppliers, were going to be going to New York to be resold there for a profit.
And counsel, I like to pick up on that because in the calls, right, between Davis and the defendant, a number of the conversations discuss meetings with suppliers, loaning money to Davis for certain purchases, and meetings, and New York was mentioned in at least 3 of those conversations.
Yes. New York was mentioned in 3 of those conversations in ways that make, and he's saying, oh, the defendant is, Davis is saying, please, I need to help me set something up. I mean, it's clear that this defendant, from all the things, he's trying to set him up with different suppliers and whatever, and he says, Tariq, try to help, my nickname, try to help set me up with this thing, and talks about if the shit works out, which obviously is code for gun transactions, gun sales, I'm going to go to New York. The up top, he almost, that's the context of that, it makes it plain that it compels the inference that it's New York. They're talking about, defendants talking about how somebody else was saying that he was selling the guns to Davis at too low a price, and that he knew that that Davis was going to take the guns up to and then they stop himself and say up top and sell them there for more money. I mean, the compelling inference, I don't know if it's the only possible inference, it's the only reasonable inference, is that this defendant knew entirely what this operation was about, and he knew that these guns were going to be resold in New York.
And there was also a conversation, I believe, between defendant and Davis, where defendant even talked about possibly meeting Davis in Manhattan. Is that?
Yes, because he was going up there, he was taking his grandmother up there, and so they were talking about New York. And I mean, really, it's the compelling inference from this is that he's an active member of this, a very involved member of this operation, which is why he was also properly convicted of conspiring to sell 10 or more guns, because he's an active member. He's just trying to introduce him to other people. He's calling on nickname basis with other suppliers. I don't know whether Your Honors, I see my red light is on, want me to address at all the counsel, the substitution. We would just say that there was plainly an adequate inquiry into the request for new counsel. The court specifically held a calendar call for that purpose, and defendant said he had nothing else to say, and what he said in his papers didn't constitute good cause for a substitution of counsel. For all these reasons, we ask that the judgment be affirmed. Thank you.
Thank you.
So as far as these conversations in which New York was mentioned, nothing was mentioned in the context of gun sales. These were all meeting to engage in recreation and the like. Davis lived in New Jersey. There's nothing to suggest that appellant wouldn't just assume that those sales were going to take place in New Jersey. And in fact, the undercover officer said that Davis kept trying to get him to go to New Jersey. All the appellant spoke about was meeting, or Davis going in for recreation or meeting for recreation. And I mean, I hope I don't offend anybody, but if I lived in New Jersey, I'd talk about recreating in New York too. So it doesn't really link to knowledge of appellant that the sales were actually taking place in New York. As far as appellant's request for new counsel, the court was obligated to make some sort of inquiry. It was a detailed list of his objections to counsel, and all the court did was say, do you have anything else to say? It wasn't, you know, well, you say that counsel did or didn't do this.
But in response to that question, he said that he didn't want to expand on anything. The defendant didn't want to add anything. He could have taken the opportunity at that point. The question was asked at minimum. It's not as if the judge just moved on.
By the same token, appellant could have taken that question as, is there anything you want to add to this application? But the application on its face was sufficient to warrant an inquiry. It wasn't, can you tell me why you say X, Y, and Z? What is the problem there? It was, what else do you have to say? And with a general question like that, appellant can't be expected to understand that he's being asked to defend what he's put in the application. It's just that he has nothing more to add to that application. So the inquiry was insufficient to determine exactly what the problems were and whether or not new counsel need to be appointed. If there's nothing else, I'll stand on the brief. Thank you.
Thank you. Thank you both. Fundus versus Scarola. Go ahead.
Good afternoon, Your Honors, and may it please the Court, Aaron Zucker of Abrams Fensterman on behalf of Plaintiff Appellant Kenneth Fundus. Your Honors, I want to start off with the Labor Law 240 issue.
Let me just ask you this question, because on that particular issue, we have the plaintiff who testified that taglines were used, this beam started spinning. But then on the flip side of that, we have Mr. Clark, who says that there were no taglines being used and it didn't spin. Does that create a question of fact, or is it an issue that, regardless of either story, there wasn't an adequate safety device?
I think it's the latter, Your Honor. So here, first, we want to say that we think that, for the reasons discussed in our brief, that Clark's testimony should be deemed incredible as a matter of law. So that would completely negate Clark's version of the account, leaving only the plaintiff's version, which would then...
Counsel, could you, this is Judge Gonzalez. Could you explain yourself? Why would Clark's testimony be incredible as a matter of law?
Yes, Judge. So I think it's a combination of two things here. So first, we have the memory loss. Mr. Clark testified...
But they both had memory loss, yes?
Right. So, but again, I think it's a combination of two things, one of which does not appear with respect to the plaintiff's testimony. So there is the memory loss. then the testimony that he provided 7 years later in which he said that no taglines were used. So there's a 7-year gap between his testimony and the accident, and the intervening accident that resulted in the memory loss obviously happened in the middle. So
But
then,
why wouldn't that be an issue that could be presented to the jury to determine whether or not the extent, like, how can we decide that as a matter of law?
I think it's the second part, Your Honor, that I'm about to get to that makes it as a matter of law. So I think the thing here is that there's a testimony of the production coordinator, Alfieri. He testifies that shortly after the accident, Clark tells him a version of the accident in which Clark himself says that taglines were used. That version was provided shortly after the accident, at which point Clark had not suffered from any memory loss. Then, 7 years later, he provides a completely different version in which he says that no taglines were used. So the combination of the memory loss coupled with the fact,
I'm sorry.
the combination of the memory loss with the fact that shortly after the accident he provided a version that completely contradicts this later version would allow the court to establish that it was incredible as a matter of law. But then I just want to add one more thing, that even if the court were to say that his testimony is not incredible as a matter of law, we submit that his testimony as is sufficient to establish that there was a statutory violation. And that's basically a twofold argument. First, he does testify that the beam began to pendulum, meaning swing back and forth. And also there's the testimony that he said there were no hard hats used, which kind of segues into another one of the issues that we raised in our brief. So
Have hard hats been held to be a required safety device?
So in our brief, we do cite some cases, one from this court, Anderson, one from the Third Department. However, we do acknowledge that there's other case law from this court in which it says that a hard hat is not. So there's conflicting authority on that point, and we say that a hard hat should be deemed a safety device. The purpose of—
Counsel, with respect to Mr. Schneider's testimony, as plaintiff's engineer, does he review Mr. Clark's testimony and posit why, under the narrative given by Mr. Clark, there was a violation of 241?
No, Judge, the expert's opinion is premised on his reading of the plaintiff's deposition testimony.
Isn't that problematic?
It's problematic to the extent that, one, that Clark's testimony is credited. And again, we acknowledge that if the court were to say that his testimony is not incredible as a matter of law, we would then have to rely on the arguments regarding the pendulum testimony from Clark to show that there was still a statutory violation, as well as the argument regarding the hard hat. And I just want to get back then to the hard hat issue. So the purpose of Labor Law 240 is to protect workers. The statute says that other devices, it doesn't limit the devices that are deemed enumerated safety devices to just those in the statute. It says other devices. The Court of Appeals has said that the language has to be construed broadly and as liberally as possible to effectuate the purpose of protecting workers. And considering all of those things, the purpose, the plain language of the statute, and the fact that the language has to be construed broadly and liberally, there's no reason why a hard hat would not be considered a safety device. Another thing that we point out to that end in our brief is that there's a whole line of cases known as falling objects. Common sense dictates that a primary safety device to protect someone from falling objects would be a helmet. So we submit that.
But we
So
know
counsel-
that there are different
Sorry.
laws that where the legislature, whether it's the city council, when they passed the helmet law for bicycles, I mean, the legislature had the ability to do this. And meanwhile, we have two precedents of this court which makes it clear that helmets is not one of the enumerated safety devices. So there was all this ample opportunity if the legislature wanted to all these years to do that, and they didn't. And right now, that's our precedent here, Mercado and Singh, and nothing has changed. And we're bound by our own precedents. Would you agree with that, sir?
Well, the court is bound to follow its own precedent.
Right. I'd like to get back to the other issue. Did Mr. Snyder, the engineer, did he see the railing? Did he do any engineering tests to determine that it would spin in the manner that the plaintiff said it did?
Did he do his own
Did he
test?
do any testing? I didn't get that from his affidavit or affirmation.
No, he didn't do any testing.
So essentially, we have an expert who just read the transcript of the plaintiff, assumed everything the plaintiff said is true. Parenthetically, were there any inconsistencies in the plaintiff's own testimony as to the number of taglines in his transcript?
Not that we could point to, Your Honor.
I was under the impression that at one time he said there were 3, another time 2. Then he said there was none at one end, which forced him to go to the other end. He didn't say that in his testimony?
No, Your Honor, I think he consistently testified 3, and with respect to the testimony regarding moving to the other end, I think it was that all of the taglines were positioned on one side of the beam. He was holding one of them, and then he had to move to the other end. That's his testimony with respect to moving in order to try to stop the beam from spinning. I just want to then go back to Your Honor. I'm sorry.
Okay, was there any other affidavits from any other of the workers? There was like a 5-person crew there, if I'm not mistaken.
No, Judge, the only...
There was 2 on one side. There was two, as I understand Mr. Clark's testimony, he was the supervisor. He was charged with cutting it and directing the workers and assisting to ease down the railing or beam, correct?
Mm-hmm. Yes.
And he gave specific instructions that nobody move, as I understand it, and that hasn't been challenged by the plaintiff. As I understand on this record so far, the deposition testimony of the plaintiff doesn't say that he never gave that instruction, did he?
He did, Your Honor. He says that he was never given an instruction in which he was told not to move or not to approach the beam. The plaintiff provided that testimony.
So we have inconsistent testimony. We have dueling stories here, correct?
Correct.
And no other worker supported the plaintiff.
Right, and
Just as no other worker supported Mr. Clark.
Right, except
So
to the
when you
extent...
have dueling positions here as to what exactly was transpiring, and we have a plaintiff's expert that only relies on the plaintiff's story, which is very one-sided as opposed to reading the entire record and being able to give an opinion with a reasonable degree of engineering certainty, that Clark's version would be impossible versus the plaintiff's version, but I'm accepting the plaintiff. Given that context, wouldn't it make sense, because you didn't lose here, sir, as I understand it, you just have to go to trial and have a jury weigh in on the credibility of what Mr. Clark said and what Mr. Fundas said. Would you agree with that?
We agree to the extent that there are 2 competing versions, but again, our position is that one version should be deemed incredible as a matter of law, and 2, even if the version of Mr. Clark is credited and were allowed to proceed to a jury, our argument is that the plaintiff still met his burden on summary judgment because of the 2 things that I said about the pendulum swinging testimony, but more importantly, the helmet thing. And I see my time is up. Can I just brief?
Counsel, I'd like to go in another direction.
Okay.
Can you tell me why the court erred in dismissing the Labor Law 200 and the common law negligence claim when the plaintiff testified that it was his employer that supervised and controlled the work, and then Columbia supervised the employer? So what was the error in dismissing those claims?
Your Honor, our argument with that is pretty narrow. We're relying specifically on the provision cited in the lease agreement between ASLP 2 and Columbia, in which there are several provisions in which it says that ASLP 2 will be responsible for providing grip safety.
Hasn't that sort of lease provision been held not sufficient to create Labor Law 200 liability? I mean, that's sort of a general provision. You need to have some specific direction and control and supervision.
Right, Your Honor, and I think our argument against that would kind of be that there were a few provisions that we relied upon, and we think that the confluence of all three of those considered together would be sufficient to just raise a question of fact. We're not saying
And basically, your main interest is the 241.
the 240 and the 241, Your Honor.
Thank you.
Okay.
Good afternoon, Your Honors. My name is Howard Strong, and I proudly represent Astoria Studios
Counsel,
Limited Partners.
let me just start here with the 240 sub 1 issue. And I just want to take Mr. Clark's testimony for what it is, right? At some point, I think it's maybe 1918 or between 1918 and 1916 of the record, he says that he was under time constraint. He was using a hoisting mechanism, not a lanyard. There were no taglines. That's his testimony as to why they performed the work in the way they did. And I would submit that nobody move is not a safety mechanism. Telling people to not move is not a safety mechanism. So taking that particular testimony as it is, even if the plaintiff's testimony conflicts with that, don't we have at most contributory negligence? Because it would seem to me that Mr. Clark himself has established some sort of proximate cause. Therefore, the plaintiff could not be the sole proximate cause. That's not how our case law works in this department. So if you could just address, I know that was a lot of questions, if you could just address that issue.
Surely, Your Honor, I shall. Obviously, there's a significant amount of contributory negligence on Mr. Fundus, but I respectfully submit that it goes way beyond that. His actions were the sole proximate cause. There are two very disparate descriptions of this accident. You have the Fundus accident, where he talks about spinning and taglines and things of that sort, and then you have the Tommy Clark version of this accident, which couldn't be more different. No taglines were used, nothing was spinning, and for a labor law 240 case, we need a falling object or a worker falling.
But here's my I guess my problem with Mr. Clark's testimony, where he decides that he's going to cut these beams in a certain way. He testifies that he could have cut them smaller, but under time constraints, he didn't want to do that. So there was no safety mechanism. There was no adequate safety mechanism, regardless of how his testimony is presented.
I respectfully, again, disagree with you, Your Honor. There was no need for anything different than what was used. They were raising and lowering this piece of pipe, which in reality was a handrail that was part of a prop. Everything was going fine. He was told not to move. No one moved, but Mr. Fundus literally ran into the pole.
If the beam wasn't spinning, does whether or not their taglines matter?
Honestly, I don't think so, Your Honor. There is a strong factual question.
You need a tagline if the beam is spinning, right?
Well, if there's a
That would
risk,
be the safety device for a spinning beam. But if the beam is not spinning, you don't need a safety device for a condition which doesn't exist.
correct.
Until it spins and then hits someone, right? I mean, at that point, it's too late.
It didn't hit anyone. There is evidence in this record. He ran into it. He broke
So,
away from the
counsel?
group. Yes. I'm sorry.
Counsel, sorry. So we had the testimony of the plaintiff, and we had the testimony of Mr. Clark, who's the supervisor, and they're at the scene. And we know that there's workers who were present, and who knows, maybe other people. Do we have anything from anybody else who was at the scene, who saw this, who could say it was spinning? I agree with this one. It was not spinning. I agree with that one.
The record does not have anything to that effect, Your Honor.
Do we need that? I mean, the quantity over, we don't need
I don't-
10 people saying one thing on one side and 10 people, we don't need that.
I
right?
agree with you. We do not need that. We have two, I want to say credible, but we have two different versions of the accident that this jury must decide and hear, so they could determine if, in fact, facts exist for labor law, findings. And
Now,
Of
especially for
course,
two-
what I'm
We know
asking
that-
you goes to the issue of
I'll wait.
credibility.
I'm sorry, I missed it.
Of course, what I'm asking you as far as whether witnesses, other than the two that Mr. Clark and the plaintiff, does this just boil down to credibilities? Is this the kind of thing that has to go to a jury no matter what because we can't decide it on paper?
At the bottom line, yes, Your Honor. Yes.
Now I'll go. So we know that there are
Sorry.
two different versions, right? But one thing is consistent with both, because Clark did testify, right, that he did go from one side of the beam to the other while it was being lowered, right? And that no one told him to do that. Am I correct about that?
Mr. Fundus went from one side
Okay.
to the other, yeah.
Okay, but what about Clark saying that he realized it was unsafe for him to do that while the beam was being lowered? Am I correct
It was
about that?
absolutely unsafe, as it would be unsafe to dart into the street when there's oncoming traffic. Absolutely.
But he did testify to that.
That Clark said it was unsafe?
Right, it was.
Yes.
Okay.
Of course, of course. It's unsafe. I just want to also mention, we had some discussion earlier about helmets. The record, I think, reflects from Mr. Alfieri's testimony, Mr. Scarola's testimony, and a safety person from Columbia, John Clements, that helmets, at least from Alfieri's and Scarola's perspective, helmets were given to the plaintiff. He did not wear one. There were extra helmets, we know from Mr. Clements, that were there. And we have to be mindful of the Robinson versus East Medical Center case, where safety equipment, and if you want to assume for a moment, arguendo, that the court will move in the direction of calling the helmet safety equipment. If it's given to somebody, they misuse it or don't use it at all, well, you can't hold the contractor, the owner, or whomever liable for those actions.
Thank you.
Thank you, Your Honors. I rest on my brief.
Your Honors, I just want to go to briefly address the helmet thing again. 2 quick points. One, I know that there is authority from this court saying that a helmet is not a safety device within the meaning of the statute. However, we do point out that there is a case from this court saying that it is, and that's Anderson. Second, even if Anderson didn't exist, this court can overrule its prior precedent. And for the reasons discussed in our brief, we think that it should, to the extent that there is that conflicting authority. And I'll just briefly talk about the furnishing of the helmets. I think at best, there was testimony that at the beginning of this job as a whole, not at the beginning of this specific day of work, but at the beginning of the job, that maybe helmets were provided. And on the day of the actual accident, at most, there were helmets available in a supervisor's office. Their only testimony is that no one was wearing a helmet while this happened. And then after it happened, plaintiff came back and miraculously now everyone's wearing helmets and he's asked to wear a helmet. So factually,
We don't, I'm sorry, my understanding is the use of conduct after an accident should not necessarily be controlling.
right, Your Honor.
Remediation, we don't, that's not, how meaningful is that?
Well, I think it just shows that the acknowledgement that previously helmets were not being worn. But regardless, the fact is, helmets were not worn. The fact that they may have been in an office somewhere, the Court of Appeals, in the case cited in our brief, Mosher said that the fact that there may have been a safety device on the job site is insufficient. It has to be provided to the workers on the day at the time of the job, and that just wasn't done here. So unless the panel has any other questions, we ask that the denial of summary judgment on 240 and 241 be reversed and it be granted. Thank you.
Thank you both. Landmark Group. Don't send them away. I'll see whether I give them a minute or not. We'll see. Let them. All right.
Thank you.
Good afternoon, Your Honors. Joseph Cook of Milburn, Macris, Plusatis, and Sidon for the plaintiff appellant Landmark Group. I want to start out first with the issue of whether the SCA met its burden of proof with respect to the motion for summary judgment, and specifically they were required to prove prima facie that none of the 4 exceptions to the no damage for delay clause were present. The only thing they offered in support of that was an affidavit from the SCA project officer and Mr. Dumitrescu, who admittedly had no personal knowledge of the contract, was not involved in the formation of the contract, and his affidavit consisted of essentially nothing more than the attachment of 42 separate exhibits which represented various contract documents, correspondence, etc. At no point did he render an opinion or a view about whether any of the 4 exceptions were met, nor did he render an opinion or comment on any delay aspect of the project. We cited in our brief the Freeman case from the 3rd Department, which is very similar to this case, where the State University Construction Fund attempted to do something very similar, involving a claim which involved both delay and change orders.
Sir, cutting to the chase here, you do not dispute that Landmark was fully apprised that when it was making its bid to do this work, that the SCA required that they acknowledge the PLA, the Project Labor Agreement, is controlling and that and would play a role in this work. You agree to that?
Of course, Your Honor.
Okay, and we recognize that the real dispute between the parties really is interpreting whether the agreement would require that the plaintiff workers be able to work an 8-hour day versus being paid for an 8-hour day. Would you agree that that appears to be how the parties are trying to interpret the PLA provision in that regard?
I see that that is the SCA's position. I don't happen to agree with it. If you look
I understand that.
If you look at the section that they're, I guess, relying upon, which is the actual PLA, the language in the PLA, which is Article 12, it's in the record at page 859, it's described as hours of work, not hours of pay. That's the very first point. So this whole idea that you can have men be paid but not work is not even consistent with the language of the PLA. Beyond that, the idea that the SCA would negotiate a PLA which pays for work that's not being performed is patently absurd. And we're not talking about a day. I want to just make sure it's clear. We're not talking about a day or a week or a month. We're talking about exterior work that went on for a year. So this was clearly not something that was contemplated.
But your client was aware in the beginning that there would be certain constraints. They were aware that because it's a school and the work started during a school year, that the work couldn't be done till after 3 p.m. on a given weekday.
That's correct.
Your client was aware that the school was close to a building next door that could take issue with any kind of noise that would be triggered as a result of demolition work, and you actually had to put in some kind of noise mediation plan, correct?
That's correct.
Which meant you were sensitive to that and sensitive to the hours of when you could work during the weekday and during the weekends. True? It was all in advance of putting in your bid.
It was contractually mandated that we start work after 3 o'clock.
And would you agree that it really wasn't the SCA, but really the DOB that really put the brakes on how long your client team could work on a given day, 7 days a week?
No. Well, our contention is that but for the PLA, we could have paid the men for the hours that were actually worked.
Weren't there restrictions from the DOB as to when the work can take place, and that was something that your client warranted, that they were familiar with the laws and regulations required to perform this job?
My client was familiar with the laws and regulations and complied with every single one of them, including, most importantly, the noise regulations. It submitted 2 separate noise mitigation plans. It's self-tested. It followed all DEP regulations regarding the permissible noise levels for the project. Not once did it receive a violation for exceeding the noise the permissible levels of noise. In fact, it went beyond that. It actually lined the chutes by which debris was taken down from the building to ensure that it met all of the DEP requirements.
Was extra work done here beyond the, was extra work done here beyond the scope of the contract? Because my understanding is that this lawsuit is predicated on the fact that your client was forced to pay for work that was not done, which means payroll monies. So you were seeking close to $1 million, well, not quite, but you were seeking to be reimbursed, not for extra work, but for payments for work not done over that whole year, correct?
The SCA's position is
No, but
that,
I'm just saying, factually.
yes, our position is
Based
that,
on your contract, you had the right to go beyond the scope of your monies if extra work was required for a variety of reasons.
that's correct.
This is not extra work. You were seeking to be reimbursed for payroll, for paying workers for hours they did not work, correct?
No, well, yes, we're seeking to get paid for time that we had to pay the men for where they did not work.
Exactly.
And that is-
And parenthetically, there were no delays here because you actually met your deadline a month ahead of schedule.
That's correct. We added additional men to make up for the lost time by virtue of not being able to get the work done in the time originally allotted. So, just to,
The definition of extra work, which is on page 473 in the agreement, any work in addition to the work originally required by the contract documents and for which the SCA issues a change order. Were any change orders issued?
no, we requested a change order. The change order was submitted to their change order unit.
And denied?
And no, it was not considered. There was an affidavit in the record from a Miss Barbara McIntyre, who was the chief of the SCA change order unit. She acknowledges receiving the paperwork, stated that she could not locate any records indicating that they considered the change order, and confirmed that they did not agree to it or deny it.
So what's your time frame for doing something about that when just nothing happens about it?
When you say we submitted,
When do you have to put in a notice of claim about that?
we put in a notice of claim immediately. The record supports that. There's no argument here on this appeal that our notice of claim was untimely. And going back from, and again, the argument here is also twofold. I know the SCA contends that the extra work, that the claim is not really extra work, that at most it's a delay-based claim. And as I started mentioning earlier, we don't believe that if we worked off the premise that it was a delay-based claim, that either they met their burden of proof, or alternatively, there's certainly issues of fact that have been raised both with respect to whether this was a contemplated delay or whether it was one that was a breach of a fundamental obligation of the contract. They represented to us that we had to follow the PLA, which they had agreed the men would be paid 8 hours irrespective of the amount of work or the amount of time that they actually worked. We followed that. We had no choice but to follow that.
Well, see, I keep going back to the beginning. You were aware of the burden of the PLA before you put in your bid.
Yes, of course, we're aware of it.
Which
Yes,
meant that it was in the realm of possibility or beyond possibility that you could have a given day where your men would only be working 3 or 4 hours, and yet you would have to pay them for an 8-hour day based on the PLA. So if you signed that contract, how can you have any cause to complain?
because the representation was that the men would be able to work 8 hours. This was not a situation where, I mean, occasionally on a construction project, you may have a single day, for example, where there is bad weather, where the men show up and work for 2 or 3 hours, but then you have to send them home and you have to pay them. This went on for a full year.
But you agreed to comply with the PLA, did you not? And didn't that PLA, I know now looking at it in hindsight, it may seem unfair and may seem that it shouldn't have been that way, but didn't the PLA at the end require that each worker working a 5-day work week for at least 2 hours a day be paid for 8 hours each day, even if he didn't work the 8 hours?
Yes, the problem is that the PLA says
It
they
went
are
on for a
going
long
to...
time.
No, the PLA says that they are going to work 8 hours, and we are going to pay them for 8 hours. There are very limited circumstances under which they might get paid, even if they worked less than that. What was not contemplated was having a job.
The PLA says there were very limited circumstances where that can happen? The PLA says there are very limited circumstances where that could happen, that they work 2 hours but get paid for 8 hours?
No, it doesn't address that issue. But again, the PLA is something entered into with the SCA. It's not an agreement that we entered into.
But you made the agreement subject to that, did you not?
Yes, and the SCA agreed to pay that money. They agreed to the unions that they were going to pay them for 8 hours, and we said, fine, we'll follow that. So when they don't work that time, we're entitled to that compensation from the SCA. That's a fundamental obligation of the contract to give us the right to have those men work 8 hours at the project site.
Sir, help me out here.
Sure.
Where in the record did it say that the SCA assured you, outside of the four corners of the document, because you just said that they represented to the unions that they would allow your folks to work 8 hours and be paid 8 hours. Where is that in the contract?
Well, it's, again, the record is at page 859, which talks about the time that they're going to work.
It says that they're going to be allowed to work 8 hours a day?
It says 5-day work week, 5 days, 8 hours, plus 1/2 hour unpaid lunch period each day.
That's in the contract?
Yes, that's part of the PLA. That's in the record at page 859. And then it goes on to establish what times they can start, based upon which shift, whether it's going to be a morning shift, an afternoon shift, a night shift. It has the starting times. And it contemplates an 8-hour work day, not 8-hour pay day.
But it says they're going to be allowed to work 8 hours a day.
Correct. And that's what didn't happen.
Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Racinas, and I represent the New York City School Construction Authority.
So is that what your contract says, that they're going to be permitted to work 8 hours a day?
I don't think so, Your Honor. I don't unfortunately have the record here with me, but that has not been a focal point of the briefing in this case. This is the first I've heard of them saying that there's some explicit reference in the PLA to that effect. I certainly don't remember reading it. If you look at the bottom of page 4
I mean,
of our
I know there was the idea that there's going to be 8 hours of work starting at 3 o'clock or 3:30, going until whether it's 11:30 or midnight. But saying that that's what the workday would be is a different thing than saying that they're going to actually be permitted to work all of those hours, because obviously there was a requirement of complying with Department of Buildings requirements, with the school situation and neighbors, as well as the PLA.
Well, that's right, Your Honor. I mean, the phasing exhibit says they have to start work after school ends, which is 3 p.m. And in practice, that tends to mean 3:30 because students have to leave the school and whatnot. And you're also absolutely right that they were not told that they had to leave the site after 5 hours or 5.5 hours or what have you. They could continue to do work at the site, but they couldn't after a certain point in the evening, which was, depending on when we're talking about, because the permits changed slightly, it's either 8 or 9 p.m., they couldn't use this debris chute.
But was the point of this 8 hour that you're not going past midnight, basically?
I'm sorry, Your Honor.
This provision about an 8-hour workday in a contract which the works is starting either at 3 or 3:30, that you're not working, the workday is 8 hours, that you work till midnight, but you're not going past midnight.
Yeah, Your Honor. I mean, again, I don't even remember exactly what he's talking about in terms of, because he seems to be talking about the PLA, not the contract specifically here. I don't remember exactly what that provision on 859 of the record says, but there was certainly nothing that I'm aware of that says that they had the right to do to use every last piece of equipment for all 8 hours of their workday, despite, natural noise concerns. And as we say in our briefing, the point here in our minds is they agreed to follow all the restrictions imposed by local regulations, including the regulations that said that you need an after-hours variance after 6 p.m. on weekdays. They agreed that they would apply for and get and keep valid permits issued by any governing authorities, including the DOB. And I think the important thing here is what Justice Schulman said, Your Honors, which is fundamentally what they're trying to say here is they are complaining about having to comply with the terms of a contract that they signed. And I would refer the court, if I may, to the end of their reply brief, where they make that point far better than I ever could, because they themselves say it. At the bottom of page 15, they say, the problem is not that the DOB limited the hours on the after-hours variances. The problem is that the SCA requires contractors to follow the PLA, which mandates that they pay for 8 hours of work, irrespective of the number of hours actually worked. So they're admitting there that the PLA does have this requirement that we say it does. Then on the next page.
Counsel,
Yes, Your Honor.
if I'm over here, I'm on the screen.
Oh, sorry, just, yes.
It's okay. So my question is, where in the PLA or in any part of the record does it reference the minimum hours that have to be paid? Sorry, the minimum hours that have to be worked, as opposed to the actual time that is worked? Because I'm looking for it. I have the benefit of being able to use my computer while I'm on the screen, and I can't find it.
Your Honor, that's an oddity here. That seems to be in the deposition testimony, not in the PLA itself, and I have never understood quite how those two things mesh. But if again,
I found it in the deposition testimony. I did not find it in the record. I did
That's
not
right, Your
find
Honor.
it in the PLA. So
yes, go ahead,
this
Your Honor. I'm
is-
sorry.
I'm not remiss.
I don't think you're missing anything, Your Honor, and I don't know if that's just the PLA, I think, is ambiguous about that, so that might just be a course of dealing between the parties here. But I think that the important thing to note is that there is this, but the minimum of hours doesn't matter insofar as it's generally not disputed between the parties, although Mr. Cook seems to be suggesting something otherwise a little bit here today. Generally not disputed that as long as that past a certain threshold, which was met here, they have to pay their workers for a full 8 hours, regardless
No
of how
matter what.
long they work for. I mean, if that weren't the case, I don't think we'd be here, because they wouldn't have paid their workers for the full 8 hours. If they're really right that, I mean, certainly if they were saying something different, that, oh, the SCA, the PLA both requires that they get paid for 8 hours and they work 8 hours, I don't even know why they would have paid them if they weren't working 8 hours. But the point here, Your Honor, is, again, in their reply brief itself and repeatedly in their opening brief, they refer to the PLA in the way that we refer to what the text indicates, which is that workers have to get paid for 8 hours regardless of how long they work, at least past a certain threshold that, again, is, according to the deposition testimony, is
If
2
Judge
hours.
Friedman, if Justice Friedman will allow me to ask a further question,
Of course.
if I
Of course.
may, would you kindly reference the timeliness of the notice of claim and the timeliness of the filing of this action?
I mean, I don't think that I don't think that's
they
on appeal, Your
untimely?
Honor. I'm sorry, go ahead.
Are they both timely or untimely? Are you saying that's not an issue?
As far as I know, it's never been an issue on this appeal and based on the Supreme Court decision below, Your Honor, unless I'm missing something. That was not the basis for our argument on this appeal, certainly, and I don't remember the trial court referencing that either. I may be misremembering, but and if I may briefly address the procedural point, or I know my time is up, Your Honor.
Finish up.
Let me just say very briefly that we think that Landmark is wildly overreading the Freeman Mechanical case, which simply stands for the proposition that, quote, conclusory blanket assertions about that the exceptions to the application of the delay, no damages for delay clause don't apply are not enough to win a summary judgment motion, that you have to make more than bare conclusory assertions. That's all that Freeman Mechanical stands for in our view, so that's not relevant to us here at all. Thank you, Your Honors.
Thank you.
Just a couple of brief points, Your Honors. First of all, counsel was talking about obtaining after-hours variances and permits. It's undisputed that we obtained all of those. That's not the issue here. The issue is, was this delay within the contemplation of the parties? And their own chief project officer stated in an email that it wasn't. He specifically indicated that this imposition of additional time would create a financial hardship on Landmark.
You're speaking about what Joseph Bova had to say.
That's correct, Your Honor.
How does that bind the school construction authority here? I mean, the things that he said. I mean, if what he said is not consistent with what the contract provides, his having said that isn't going to make them liable, is it?
I don't think that's what the contract provides, Your Honor.
I
think
understand
it's-
that, but if we were to conclude, if our interpretation of the contract was different than yours, what Bova had to say about this is not going to mean that our interpretation of the contract is incorrect.
No, but I think it does raise a question of fact, Your Honor, as to what was the contemplation of the parties at the time of contract execution, and that's not something, that they've introduced any evidence of. We talked very briefly a moment ago
Because
about framing.
by very usual contract principles, we would first have to find that there's an ambiguity in the contract before we would go to that extrinsic evidence. Isn't that so?
Again, I don't think this is an extrinsic evidence issue. I think this is a delay claim issue as to whether it was within the contemplation of the parties, because the SCA is claiming that the claim is barred by virtue of the no damage for delay clause. And again, we think not only did they not establish a prima facie case, as evidenced by the comparison to Freeman, there is also ample evidence, such as Mr. Bova's email and other documents, that indicate that the SCA always believed that this was not something that was contemplated by the parties. In fact, their phasing exhibit, if you look at it when the job was bid, it specifically identifies the times that work was to be done, and it also includes a 20-day productivity loss that you're supposed to factor into the bid. There was no mention whatsoever of any potential lost productivity related to DOB restrictions or anything else.
Counsel, I'd like to go back to the extra work claim, because I pulled up pages 44 and 45 on the record. And as it relates to that claim, the complaint indicates that the claim is for additional costs that were incurred due to the delay. So if the extra work, which is defined as in addition to work originally required under the contract, how can this be a claim for extra work when your own complaint says that you're looking for additional costs, additional expenses because of the delay?
Well, we're looking for additional costs associated with that additional time. Let me give you an example.
So what was the work? Because I'm looking at it and I don't see that you laid out we had to do X, Y, Z. What was the additional work in addition to what was agreed upon in the contract?
Well, let me give you an example. So if I have to have
No, I don't want an example. I like to know, like in the complaint, because I don't see it.
Well, I cannot have the complaint in front of me, but what I can say is that each time that the man can only work 4 hours instead of 8 hours, they have to clean up, they have to demobilize, then they have to, for the next time they come back, they have to reset up and remobilize. So those types of additional costs are beyond the scope of what would initially have been priced under the contract.
Okay, because I have it right here, pulled up on my phone, and what you said, it's really a repeat of the first cause of action. So, okay, thank you.
Thank you. Thank you both.
Thank you.
Verdugo versus Smiley and Smiley. Justice Kennedy is recused on this. In the event that there's a tie vote, a fifth judge will be vouched in.
Good afternoon, Your Honors. May it please the Court. Dave Zegarelli for Flomenhoft. Thank you very much for giving me the opportunity to argue, so I'll cut right to the chase and be as brief as possible. The 2015 sealing order should be vacated for many reasons. First and foremost, Supreme Court failed to do any good cause analysis or balanced interesting before it blanketly sealed the guardianship file in 2015. I'm sorry, go ahead.
I'm sorry, that's not an issue here. The issue here is whether it should be unsealed because of this court's decision to consolidate the guardianship proceeding with the fee proceeding and the malpractice proceeding, and with all of it being consolidated based on your briefing that it's all one organic whole, that Mr. Flomenhap et al. Should have been given the right to be able to have access and be party to that proceeding, correct? So you want it unsealed so he can have access to the information there?
No, absolutely, absolutely, Your Honor.
Isn't that the central issue on appeal here?
That is correct, Your Honor. The sealing order became obsolete when Supreme Court issued, right, the November 2020 consolidation order, right, fusing all three matters. Flomenhoff essentially became a named party defendant to the consolidated proceeding. You then have essentially one single action under one caption, one index number.
And so your view is that the court below erred in somehow treating this one guardianship proceeding, because there's only one, as being somehow bifurcated by the sealing, so to speak.
Correct, Your Honor. And as we point out in our brief, sealing irreparably harms us. It blocks us from accessing the court file of this very case. Again, a case to which Flomenhoff is a named party defendant. Your Honor, if I may, when we attempt to obtain copies of court files, we are essentially given the stiff arm. We can't obtain copies of entered orders. We can't obtain copies of our own motion practice. The sealing
Counsel,
order.
did you ever, counsel?
Oh, I'm sorry.
It's okay. Did you ever ask for in-camera reviewed?
For an in-camera review of what, Your Honor? Of the guardianship documents?
Yes. Would that work for you? So that redaction could, I don't know if there's anything that would be outside of,
well, Your Honor,
outside of your purview, but.
right. Well, and I think what you're alluding to, again, is the fact that right here we have blanket sealing, which flies in the face of the presumption against sealing. Your Honor, respectfully, let the sun shine in. There's no reason why we can't have open and transparent proceedings here.
I'm not disagreeing with you. I'm asking you whether, given any concerns that may have been voiced as to confidentiality or anything else, whether either party asked for in-camera review or indicated that there was certain sensitive information that should not be shared.
Well, going back to when the sealing order was issued in 2015, we weren't even a party to any of these proceedings, so we were in no position to request in-camera redaction. And right now,
Who should go first on the redaction issue? Is that something that the court should have initially said, well, I need to redact such and such because it should remain confidential? Is that something that the court should have done ab initio before sealing or instead of sealing?
well, Your Honor, and this is actually what sort of segues into my initial comment here. There's no indication that, again, a good cause analysis was conducted.
Your point is we start off that everything's supposed to be open unless there's a compelling reason to seal it.
Correct, Your Honor.
So if we're sealing it, and so who's sort of starts out, who's got the initial burden to say, well, this should be redacted?
It should be the proponent of sealing, which is obviously the guardian, not us.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. I'm the court-appointed special guardian, Lisette Ferreira. And
Doesn't our consolidation order sort of point in the direction of undoing this sealing?
I don't agree because of the unique context of the guardianship. I think it's different to consolidate two standard civil cases than when you consolidate a guardianship. In a guardianship, you don't have the same parties. You don't have a plaintiff and a defendant and perhaps a third-party defendant. You have initially a petitioner and a respondent. You have what we called interested persons. You have court appointees. Each one of those have different rights, different responsibilities, and different standing. I think the initial, so I don't think that when you consolidate a guardianship case with another case, that makes the parties to the other case now parties to the guardianship.
Well, counsel, in terms of the claim that was filed, was a malpractice action, does that place the guardian's capacity at issue in some way that maybe now the record should be open?
I don't think so. I think that the issue of the incapacitated person's
Incapacitated person,
capacity
yes.
is not at issue for a number of reasons. It's not an issue here in the sealing issue for a number of reasons. One is that when the court ordered the consolidation, there had not yet been an application to terminate the guardianship based on allegations that the person had regained capacity. So that could not have been a consideration for the consolidation. What this court's decision found was that there were intertwined issues with respect to the Peachtree loans. And those intertwined issues on the Peachtree loans only go to the malpractice and to the fee dispute actions. Those are not issues in the guardianship. And I think ultimately by having, the cases where there's open access, these are cases where the media is seeking access, where there's a public interest or there's a public figure. What we have here is a litigation strategy, a self-interested person who's involved in litigation against an incapacitated person seeking to weaponize the guardianship proceeding to have access to information that is privileged, sensitive, confidential, and otherwise protected.
I'm a little confused because when this court issued its October 2020 order, and I was on that panel, we made it clear that it should be consolidated, not parallel proceedings in a joint trial context, because we found that the issues are inextricably intertwined. The whole issue is whether there was overreaching in the context of the Peachtree loans. That seems to be a common thread here, whether somehow Mr. Vertigo was incapacitated to the point that he was not competent to sign for those loans to help pay his rent and all the other aspects of which the loan was supposed to take care of. Therefore, this court reversed the lower court in determining that was an issue of fact. This court found that we believe that Peachtree loans have to be set aside, and therefore that becomes an issue.
It is no longer an issue in the guardianship case.
Well, I understand that because you settled.
Well, that litigation settled.
Which is ironic, because the guardian moves to eliminate the obligation of the plaintiff here to have to pay those loans back as the borrower, and yet you paid $55,000 to settle on the very claim that you claim you shouldn't have to pay.
That would be the guardian. I'm the special guardian appointed after, but I understand your
Counsel, I know you're the SG. I got all that, but we can't escape that reality. A proceeding was started to set aside the Peachtree loans as not being an obligation of the plaintiff here, and because of lack of capacity, which is a defense to a contract, correct? And that started the separate action that Peachtree has against everybody else. Well, if he won't pay it, someone else has to pay it. But in that context, the guardian paid $55,000. You don't dispute that?
I do not dispute that.
So now the whole issue is whether the Floman-Half firm overreached here in terms of self-dealing. And again, I'm not characterizing, I'm just trying to get cut to the chase. So you have a malpractice action brought by the guardians against him for forcing him to go into the loan. You have the fee proceeding where Mr. Floman-Half was the affirmative actor who's saying, look, I did a lot of work with the Smiley firm to generate all this that led to the $5.5 million settlement, and I want a piece of the action. Okay, that's an issue. And then you have the guardianship proceeding where there's a pending proceeding in which the daughter of the IP is seeking, and arguably the IP is seeking to vacate the guardianship proceeding and allow him to move forward. So they're all inextricably intertwined. And it's against that backdrop that I'm struggling to understand why the lower court was blocking Mr. Floman-Half after our order specifically directed him to move to consolidate, because we found on this record since 2000, 6 or 4, it's an old case, and all these appeals, that this is all inextricably intertwined. So why wouldn't fundamental due process warrant him being able to have access and be a party to the guardianship proceeding?
Well, the termination that you mentioned and the application by Fatima Verdugo to terminate the guardianship that raised the instant capacity issues had not been filed at the time of this consolidation order. It was filed more than a year later. I think that in the guardianship court, in implementing this court's directive for consolidation, acted under the mandates of Article 81, because guardianship is different. And I think that under those mandates, to have the person litigating against Mr. Verdugo have access to the guardianship file would be inappropriate. In the malpractice action.
Counsel, if I may, I'm over here. Hi. So if you have objections to certain records that you deem are confidential, can't you make an application that those records be reviewed in camera?
Well, I think that to the extent that Flomenhalf is seeking, what they're seeking is discovery for the malpractice action. And to the extent that that's what they want, I think they should make that application in the malpractice action. The other thing is, to the extent that they're alleging prejudice, the documents that they're seeking.
Did you answer my question?
I think that it should be done through, I don't think that it should be a precedent set that in these particular circumstances, they should be accessing the guardianship file, and I don't think that they should be conferred party status in the guardianship. So I don't think
So
they
you
should
continue
access
to
it.
advocate for a blanket sealing, basically. Okay, thank you.
You're welcome, thank you.
Oh,
No, you're,
right. I'll just be very brief. I don't, oh,
One question, kind of to piggyback off what Justice Gonzalez said to you.
okay.
Yes. Would a protective order be suitable in this situation where there are certain guardianship records that you should maybe shouldn't be privy to? Or you just need everything? You need blanket access? Once it's unsealed, it's unsealed.
Correct, Your Honor. No, it's our position that there should be no in-camera, no partial, no protective order, because there's no basis, no case authority, no statute that justifies blanket sealing here. I'll just add
Well,
one.
it's two different things. Blanket sealing, if it's unsealed, maybe there's a protective order or some kind of redaction that could satisfy the equities here.
Your Honor, respectfully, I think that would be difficult to implement. And again, it's our position. I don't understand what's confidential here. There's been no argument, no showing as to what constitutes confidential documents in this matter. The salient theme, the common thread that runs through the guardianship proceeding, the malpractice action, and the fee allocation proceeding is the IP's capacity. It's the common thread that runs throughout. Unless a member of the panel has a question for me, I'll rest on my brief. Thank you.
thank you. Thank you both on this case. I'm calling the next Verdugo versus Smiley case, and I understand that someone has appeared from the Schwartz Law Firm, which did file a brief. Yes, I don't believe you made a request for time, but I will, this is a non-enumerated appeal, so argument has to result from a request, but I will give you a minute to argue.
Good afternoon, Your Honors. May it please the Court, Scott Horton, counsel representing the defendant's appellants in this matter. It's our contention, Your Honors, that the motion court's denial of the recusal motion was erroneous in light of both the extensive ex parte activity in this case and the judicial investigation of a litigant in a matter that's sub judice. While the motion court found that the activity in question was not ex parte, its rationale that this
I know
court's
this may relate to the other appeal, but it's your brief which really sets it out. At the end of the day, the money issue as to as the Flamhoff Law Firm came down to $4,893, right?
That's
I
what
mean,
the
there
record
was-
shows.
There was an adjudication that 35,000 in funds that they took were appropriately taken. Did I get that number right?
No, I believe that is correct, Your Honor. I'm just looking for
40,
that
no,
footnote.
actually, $43,806.99. That's your, that was a legitimate expense.
That's correct, Your Honor. And referring specifically to footnote 6 and page 9 of the appellant's brief, it lays out exactly how the analysis goes to show that at the end of the day, there's about $5,000
And
at
at the same
issue.
time, while there's this $4,893 that is an issue, in excess of $400,000 has been expended in legal fees from the guardian estate for legal fees contesting this. Is that it?
That's what the record shows, Your Honor, as well, and that's part of what we endeavored to point out to the court, is the patent inequity of the entire situation, and ultimately...
Is that what is that $400,000 has been expended out of the estate in order to litigate the $4,000?
That's what the record shows. I can't state with certitude that the entire $400,000 is related specifically to that claim, but yes, it's been an overwhelming amount of legal fees generated at the expense of the incapacitated person to recover what amounts to $5,000.
And also what happens here is that Mr. Verdugo moves to be relieved of having a guardian. The person that has the guardian asks to be relieved, and the daughter asks that the guardian be relieved. And some of the backup for that is this, Mr. Verdugo prosecuted his own divorce case pro se, did he not?
That's correct, Your Honor.
And Supreme Court approved of the divorce judgment, of the divorce which he brought to judgment, including financial issues, et cetera, so that in one courtroom you had Supreme Court saying he was competent to enter into this divorce, while in another courtroom we have all sorts of proceedings going on to continue the issue of whether he's competent or not?
That's exactly what the situation was, as we point out in our brief, Your Honor. Another really incredible situation that's evolved in Mr. Verdugo's guardianship. And if I may, I see that my time is up. I just want to revisit a point Justice Schulman had raised in the earlier oral argument, which I think is really the linchpin of the recusal issue, and that is this court's October 8th, 2020 consolidation order ordered the consolidation because the issues were inextricably intertwined. And one of the issues specifically noted by this court was Mr. Verdugo's capacity. And when this court subsequently rendered determination on a statute of limitations issue, it again revisited the issue of Mr. Verdugo's capacity. It's not an overstatement to say that the issue of Mr. Verdugo's capacity is the common thread that runs through all three of these proceedings. So for the lower court to be conducting extensive ex parte proceedings on the issue of capacity, leaving aside the judicial investigation of a party in a matter sub judice, we submit, Your Honor, that the evidence in favor of recusal here is overwhelming. And we respectfully submit that under the circumstances, the motion court erred in denying that recusal application.
Thank you.
Thank you, Your Honors.
Special Guardian, Your Honors. With respect to the assertion about the divorce case, the then guardian of Mr. Verdugo at the time of the divorce action was his now ex-wife. As his guardian, when she was his guardian, she surreptitiously moved in the divorce court for a divorce against the incapacitated ward without advising the divorce court that he was incapacitated. and as a result thereof, she was removed by Justice Kennedy as guardian of Mr. Verdugo. So the claim that Mr. Verdugo prosecuted his guardianship on his own and is therefore, not incapacitated.
Is it true that in June of 2022, Mr. Verdugo was licensed and certified as a home health aide by the New York State Department of Health?
I don't know if that is true. With respect to the divorce case, his guardian was removed for prosecuting that surreptitiously. With respect to the issues about the information that the capacity issue, the capacity issue is for 2007 to 2008. That's the time of the Peachtree contracts. That's the capacity issue at dispute in the malpractice and in the fee dispute. That is before this guardianship proceeding even started. And in 2007 and 2008, the time period for which they are seeking records, the Floman half was the PI attorney for Mr. Verdugo. They represented him. They had access to his medical information. And they know how to get those records. And there's another action in which it can be obtained. But with respect to the recusal, it goes back to—
At this point, they have everything, don't they?
I'm sorry, I didn't hear that.
At this point, they have everything that's been in the court file.
I believe that's probably accurate. They did obtain access to the guardianship.
I mean, our
file.
discussion about the access to these documents is really academic, is it not?
In some ways it is, but I think that the principle and the concept of whether a adversary, a litigating adversary in another case is become a party to and have access to the guardianship file of the incapacitated person continues to be an issue and continues to be an issue and will continue to be an issue because these cases are ongoing. And so to the extent that there are additional documents filed in the future, whether or not they would continue to have access, I think is a critical issue. But I agree, they've conceded that they obtained Mr. Floman half represented he was a party to the guardianship and obtained access to the guardianship file. So he should know what's in there. So and he can seek it in the discovery. And with respect to the recusal, also, with respect to the information that's in the record, I will leave it to the Schwartz firm to address the issue of the amounts at issue in the malpractice and fee dispute to which they are a party. But I do want to say that the confidential information at issue here is the psychological, psychiatric, mental health, and general physical medical doctors' information and reports of which—
So, counsel, this is Judge Gonzalez. So this is where I don't understand you. If the big question is mental capacity, don't those records bear weigh heavily in a determination as to whether the incapacitated person had capacity to enter into this litigation loan agreement?
I don't know what specific documents they are seeking, but if they are seeking documents from 2007 to 2008 that are relevant, that they believe are relevant to that inquiry, then I'm saying that the appropriate forum to do so would be in discovery in the malpractice or fee dispute. And just to be clear, they have not been barred access to the files in those actions in which
Don't they have all the documents already?
I believe as a matter, I can't speak for them.
We're having this discussion about, they got access to the court file. I mean, there was an issue whether they should have gotten access to the court file, and I think sort of by what we did in our prior order, we resolved it in, it seemed to me, probably in their favor. I don't say that with certainty, but there isn't a specific document, is there, that they want, that they haven't seen?
Not that I'm aware. I mean, Your Honor, I believe that this is a contrived litigation strategy to further their arguments for recusal, and I don't believe that there's any basis in it.
But to play it out a little bit, let's say you go back and you're at trial, which is really, I mean, I'd like just to see it end. It's in 2004. Okay, but.
I think everyone
I
would.
mean, it's a goal, it's aspirational, I tend to always be that way. So at trial, if everybody's in the courtroom, guardian proceeding, fee proceeding, malpractice proceeding, all focused on what happened between 2007 and 2008, and in understanding that the common thread, as I see it, is the capacity. And we need to understand whether Mr. Flomenhoff arguably overreached there, because if he didn't overreach, then arguably he should be entitled to a percentage of the fees the same way the Smileys were entitled to a percentage. I mean, that's what this is all about the money. So would you not agree that everyone should be in the room and a full airing of this?
But I agree there should be a full airing, but I think that the context in which it's done matters, because I think that if the holding, if what's held is that the consolidation of a guardianship matter with another, matter would make Flomenhoff here a party to the guardianship, that means that if the guardian wants to, for example, make an application to relocate Mr. Verdugo, to change counsel in the malpractice action, anything that they make, any application they make, that now Flomenhoff would have standing to be heard on that and to have access to, continued access to Mr. Verdugo's innermost life, which is not appropriate.
Thank you.
Good afternoon, Herbert Rodriguez from Schwartz, Golson, Campisi, and Cates. I have had this action, I've handled this file almost 20 years, and I will tell that there's one many damaging record, and that is on page 367 to 376 of the record. And what happened here is that after the court issued its consolidation order, right, it said that Flomenhoff needed to move the court in order to consolidate this thing. So what did he actually file? He filed an order to show cause, found in the record, where he merged two things: the fee dispute and the malpractice claim. Nothing else. Nothing else. There's a disconnect between what he actually applied for and what the court may have thought or given him authority to consolidate the guardianship as well, or what have you. So that record is the most damaging thing to their argument. Why? Because Judge Sharp was correct in saying, hey, you're not part of the guardianship proceeding that recently started in terms of terminating the guardianship. You're not part of that case, and therefore there is no ex parte communications. Now, in terms of prejudice, Flomenhoff was the attorney that represented Verdugo early on. In fact, I was an associate at that firm. A year after I left to Schwartz, and Campisi, the wife approached the firm and said, can you take over this case? Because he's now going to Jacoby Myers having all sorts of issues, and he wants us to sign all these documents. When I took over the case as an associate of Schwartz, and Campisi, there was other additional files, medical treatment, medical records, which are protected by HIPAA. Flomenhoff never asked for an in-camera review of documents, never moved to vacate the sealing, and this is a post hoc rationalization of him putting his hand in the cookie jar
Well, we're talking about they're
first.
being barred from seeing what's in a court file.
I'm sorry?
We're talking about we're not talking about them seeing what's in your attorney file. We're talking about them being barred from what's in a court file.
Correct. And you make an excellent question, you asked this excellent question about, is this academic? If he went and, despite the sealing order, with no in-camera review, with no motion to undo the sealing, put his hand into this file to pull out these records. What's the harm now? He's already seen them. No, at trial, he should be precluded as a remedy to use them in any way, because he should ask for permission first. And his order of show cause, which merged two things, did not include the guardianship. In addition to that, the guardianship issues of terminating the guardianship and all other things all of a sudden came out immediately after he invaded the sealing order that Kennedy put in there when she was in the lower court. And all of a sudden, all these lawyers show up out of the woodwork. I'm going to represent him pro bono. Let me
Well,
do.
is it true that Mr. Verdugo has been licensed and certified as a home health aide by the New York State Department of Health? I mean, but then we're facing a situation that he's got a guardian, and he's someone that's being sent around to care for other elderly or sick people. Is that true or not, that he's been licensed? I mean, it's been in the case. I mean, it's not,
Correct. I saw some representation by the Flomahalf parties that he's all of a sudden cured from a traumatic brain injury that was consolidated, permanent, and debilitating in nature. Be that as it may, even if we assume for argument's
He
sake
may
that
not be perfect, but he may have improved. So is this true that he's been licensed as a home health aide?
Your Honor, respectfully, it makes absolutely no difference. The issue was Flomahalf's past conduct during the time the medical records reflect
So
that
you
Verdugo
would
was
agree,
impaired.
I'm sorry, I didn't mean to cut you off, sir. You would agree that all of this is about whether you should give up a certain portion of your fee to him?
I would say under the law, your first ruling of the Appellate Division, the first ruling of the Appellate Division was whether or not the fee dispute, which at the time was not consolidated, it was on its own. By the way, costing Verdugo, zero. He wasn't even a party. We were arguing over our fee. The cost to the Verdugo
I understand, but
was zero. But
sir, you understand what happened. Your firm, you went to your firm. I don't know where the Jacoby Myers came from, but I do know on this record you had Smiley and Smiley. They retained Mr. Flomenhap as trial counsel because we're dealing with the TBI, et cetera, et cetera. And somehow we have this 2007-2008 period and the Peachtree loan that seemed to be driving this whole engine for all these years. So now I'm trying to understand what we're really left with. You did set, it's not a secret, you settled with Smiley and Smiley,
because they
correct?
did nothing wrong.
Okay,
There was
just
no
saying
acts
you
of
settled.
malfeasance.
I'm just.
Because Smiley didn't commit acts of malfeasance. He didn't misappropriate the client's money. Whether it was $4,000 or $4 makes no difference. I've never seen a case where it says you can steal from a client, misappropriate client funds, but if it's $4,000, maybe we'll look at another way. No, the issue is as a matter of law.
But the disciplinary proceeding was dismissed, basically.
Actually, not accurate. That's the argument that Flomahalf wants to believe.
Depending on litigation. Depending on litigation.
And so what we were told is, once this case ends, it's been 7 years, and you may wonder why.
You can bring it back.
We're going to go back there and see what happens. So this ship, for Flomahalf, can never find a port. And this is why we've had 7 years of litigation. TROs, appeals after appeal, and motion practice, and recusal. Even the recusal, by the way, of Sharp, not the first recusal motion. The first recusal motion was against Justice Kennedy when she ruled you had to turn over the documents, as the Appellate Division said. And what happened when you ordered that he needed to turn over the financial documents? The dog ate my homework. They're lost. They're gone. And so we endeavored to go look for these records with other lawyers that he worked for, found other records that were important, took a deposition that 7 days of deposition to establish it was misappropriation, because as a matter of law, he is not entitled to a fee if he commits an act of malfeasance. That is as a matter of law, and that was the Appellate Division's decision, the very first appeal that was done. Regardless, back to the recusal.
And that's driving that position. If you could prevail on that, you could wipe out their fee.
Correct, as a matter of law.
Thank you. Thank you.
Thank you.
Very briefly, Your Honors, I'd like to touch upon a question asked by Justice Friedman numerous occasions, and the respondents were a little uncomfortable answering it. The answer to your question is absolutely unequivocally, Mr. Verdugo has been certified as a home health aide by the state of New York, and that occurred in June of 2022. And that's not just the appellant or the Flomenhalf firm saying it, that's Mr. Verdugo saying it. So Mr. Verdugo submitted an affidavit. That affidavit was submitted in connection with my stay application to this court. It appears in this court's file, and this court can certainly take judicial notice of it. The second point I'd like to make is in connection with Justice Gonzalez's question with regard to the issue of capacity. And the issue of capacity is brought into, let's say, the legal malpractice claim because Mr. Verdugo's counsel raised that issue. They affirmatively brought the issue of his capacity forward. So as a consequence of that, you forego certain rights to confidentiality for your medical records, right? When you commence a litigation, that's exactly what transpired here. And so when we look at that, we see that if you're going to affirmatively put Mr. Verdugo's capacity in issue, that's why the three matters are consolidated. And lastly, Your Honor, I see that
Your adversary, counsel, your adversary says that three matters were not consolidated two matters were consolidated.
That's absolutely a reinterpretation of what this court said. This court said a
No,
consolidate.
not what this court said, but what Mr. Flomenhoff did.
No, Your Honor. So Mr. Flomenhoff, following this court's directive, made an application to consolidate, and the consolidation motion was granted by the lower court at page 42 of the record. This court can see
I guess the question is, when he moved to consolidate in the order to show cause, was it just the medical malpractice and the fee dispute, or was it for all three? I think that's what counsel was trying to point out. And you're not really answering the question specifically.
It was the two plenary proceedings with the application being made to the guardianship court. So the guardianship court grants the application and can look at page 42 in the record respectfully. It says what it says. The guardianship court specifically granted consolidation of the three matters. And that's why when we talk about plain language in a court order, just like in a contract or in a statute, the plain language is what controls here.
And there was was there any motion to re-argue that courts?
And that's the last point that I wanted to make, Your Honor, because listening to the respondents here, they're essentially challenging what this court did back in October 2020. They're saying the consolidation of the three matters wasn't smart. It wasn't prudent. But you know what? It was done. And nobody appealed. Nobody made a move to re-argue. Nobody made a move to modify. Nobody made a move to renew. That's the law of this case, and it's clear and it's unequivocal. And the byproduct of that complete organic fusion and consolidation is that significant amount of ex parte proceedings have occurred, not the least of which was and is an investigation into a party to a matter that's sub judice. So the court is on one hand investigating a party while simultaneously purporting to be an impartial arbiter and presiding over a plenary action involving that same party. I've never seen that.
A motion is made to dispense with the guardianship, and the court's response to that was to appoint a special guardian. Why didn't the court go to a hearing on the motion to dispense with the guardian?
It's really, again, just sort of one of these incredulous, incredible things that's transpired in the context of this guardianship. It doesn't matter why someone files a petition. And by the way, the appellants had their own petition to terminate the guardianship at the time that they were being excluded from the guardianship proceedings. So yes, Your Honor, you're right on point. Instead of holding the capacity hearing, the court decides it wants to look into why I need to hold a capacity hearing. Why is this petition being filed? Notwithstanding the fact that Mr. Verdugo first voiced in 2017 that he didn't want this guardianship in place. The entire situation, Your Honor, it's just one incredible sequence of events from the beginning, almost following after this court's consolidation order. What seemed to be a pretty straightforward directive from this court, which initially the lower court followed. Page 42 speaks for itself. She ordered the consolidation pursuant to this court's directive, was very, very clear in doing that. But after that, it seemed like things went off the rails because there was this need, seemingly, to keep one party out of the consolidated matter.
Thank you.
Thank you, Your Honors.